The driver of the truck that collided with the Humboldt Broncos bus is scheduled to make his third court appearance today. Jaskirat Sidhu faces 16 charges of dangerous driving causing death, while each carry a maximum sentence of 14 years in prison. He's also charged with 13 counts of dangerous driving causing bodily harm, which carry a maximum sentence of 10 years. Joining us this morning is criminal lawyer and partner at Heinen Hutchinson LLP, Danielle Robitaille. Thank you so much for being here.
My pleasure.
So let's start first. Today, Sidhu is expected to choose how he wants to be tried. He can choose for the matter to go to a provincial court, or it could go to a higher court. Danielle, can you take us through what each option would mean?
Sure. If he elects to be tried in the Superior Court, he would then have the ability to have what's called a preliminary inquiry in provincial court. And what that is really is a bit of a dress rehearsal for the Crown and a discovery process for the defense. What the consequence is to the public is there's a publication ban, and so the public won't really know what evidence is adduced in the course of the preliminary inquiry. It's only after the preliminary inquiry, where it's expected he would be committed to stand trial, that he would have a full public trial in Superior Court. He could also elect to simply go straight to trial in provincial court, which is, of course, a public proceeding. And that decision is a highly tactical one that depends on the circumstances of the particular case.
The RCMP have released very little information on why charges were pressed. RCMP Superintendent Derek Williams only said there was evidence that the motor vehicle was being operated in a way that was dangerous to the public. So what would the Crown need to prove for Sidhu to be found guilty?
So the Crown has to prove that he drove the truck in a manner dangerous to the public. And what that means, in essence, is the Crown has to show a marked departure from the standard of care of a reasonable driver. It's a very tough test to meet for the Crown. These are very challenging cases, most frequently. And it depends on the manner of driving. Are they going to allege that he was driving too fast, that he failed to yield, that he was distracted, that he was asleep? We don't know. But the Crown will have to put up a case alleging that he drove in a way that was unreasonable in all the circumstances.
If Sidhu does choose for the case to go to a higher court, given the emotional nature of the case, would it surprise you if he chose for a jury to hear it?
You know, it would surprise me. It is a highly emotional case. You know, the difference between juries and judges is that judges are trained to disabuse themselves from the emotional nature of a case and decide the case on the facts and the law. With a jury, you worry that they'll be inflamed by the tremendous tragedy in this case.
Despite the global attention that we've seen in regarding to this story, we've actually heard relatively little about the legal proceedings since. Why do you think this is?
You know, I think it's a real testament to the professionalism of the actors, the legal actors in our system in this case, that we're not seeing, you know, inflammatory press conferences from the RCMP, that the defense lawyer isn't holding court on the courtroom steps, holding press conferences, that everyone is kind of doing their job, staying in their lane, and acting responsibly, I think is a real testament to our system of justice that is really focused on the facts and the law.
Danielle, thank you so much for being here this morning.
My pleasure.